Hello everyone. Welcome to those of you at home. Nice to see you again, Tobias. I've missed you. Sure. All right, so today what I want to do is just really high level work out where, if any, your issues are with intention to enter into legal relations. And then I thought we might play a very high stakes game. I am going to ask you to work in teams, and we're going to have some questions around intention in particular. There is a very valuable prize. There is a trophy, as there should be, and there will be the very, very valuable prize of the team gets to nominate the pop culture reference around which I will try and write you a problem for your second instalment. So it's your chance to just make it hard for me. Last semester, somebody came up with characters from a movie that I still haven't watched. So it was entirely due to my son explaining the movie to me. It was The Usual Suspects. Sounds like a great movie. I really wish I had time to watch it. And and Wikipedia. So intention. I'm just going to close this door to make it a little less bangy, but not entirely because I think it locks still. So we'll get another 10 minutes. Intention. Why do we need to know about intention? If we don't need to know about intention, we can go. Why is intention important?
So we can ascertain agreement?
So we can ascertain whether we have what kind of agreement? A binding, a legally enforceable agreement. So intention is one of the elements of a binding enforceable agreements. The other elements are offer and acceptance, which actually they're subsets of an element that we call agreement. We don't always have to have offer and acceptance, do we? If we can't find those, what do we look for? We use an objective test to find. What are we looking for if we can't find offer and agreement? We need to find evidence of mutual assent. For bonus prizes here, that will just be me sleeping well at night. A good case to help you work out whether you can find mutual assent would be? Brambles would be absolutely perfect for that. Well done. What are the other elements? So we've got agreement. We were already talking about intention. We started there. Consideration and certainty. I know it's kind of boring to go through those each time, but you need to be able to really quickly, and I know you don't know what each of the elements are yet properly, but you need to really quickly go through that checklist in your head, because in this subject, the problems are going to go to, is there a contract? You're not calculating damages, you're not thinking about what the merits are, you're not thinking about frustration or what the remedies might be. What you are thinking about is there a contract at all? And the questions that you will be asked are, is there a contract to sue on? Don't worry about what the damages might be or whether there's a breach of the clause. Is the clause incorporated in the contract? Is there a contract at all? So your first go to how am I going to solve that problem is start with are all of the elements for formation present? So can I find agreement? Easiest done when I've got an offer that matches with an acceptance. So if I can find that, ace. Dealt with. But if I can't find that, then I need to turn my mind to objectively whether, using the test in Brambles, there might be mutual assent, so that we can see a meeting of the minds, consensus ad idem. Then I need to think about my offer as kind of encapsulating this DNA of the deal. So it needs to have consideration. So consideration, I just let that slide by before. We no longer just call that price because we're well informed about what consideration is. What is consideration? It's something that the promisee gives. What are they giving?
Something of value.
Something of, does it have to be a huge amount of value?
No, sufficient.
It needs to be legally sufficient. And what's the definition of that thing of value? What are they paying for?
It's given with the intention to create a contract.
So it is absolutely linked to intention, and that's why I want to talk about, sorry about that, Lexi. Oh, you poor thing. Sorry, I'm blocking the door a little bit.
Yeah.
Sorry, I lost my... That was quite acrobatic there. You did a good job. So we've got something that has legally sufficient value. It needs to be sufficient, but doesn't necessarily need to be of adequate or equal value, which is given in exchange for or as the price of the promise. So consideration moves from the promisee to the promisor, which basically means if you make a promise, that promise will only be binding if you receive an exchange for it, and the exchange or the bargain element is really important because of which case? Woolen Mills is, Woolen Mills is absolutely there. So as a consequence of Woolen Mills, we know it doesn't just have to be incurring a detriment in order to get the benefit. So if I'm going to have the right, an enforceable right, to make you keep your promise, that's my benefit, I need to have incurred the detriment that I have made a promise or I have paid for that. So that the language that we use is that consideration is the price of the promise. Consideration moves from the promisee to the promisor. I get tongue-tied thinking of it that way. I just think of it as consideration needs to move both ways. Both parties make promises and both parties receive promises or value in exchange for the promises that have been made to them. Consideration must move from the promisee, so the person who receives the promise, but doesn't necessarily have to move directly to the promisor. So we might have an arrangement where I can require payment to be made to a third party, for example. But we'll talk more about that when we get to privity. Certainty, don't worry about it right now, other than to understand that in order for us to have an agreement, ideally in the offer, because that's the easiest way, but the agreement itself needs to contain all of the DNA, because it becomes an agreement at the point in time where it's accepted. So that means we need to be able to see in the offer or in the agreement what the promise is and what it is that will make that promise binding. So if I make you an offer to sell you my coat for $25, it is quite clear that my promise to transfer ownership of the coat to you requires you only, once you accept that, you will be bound to pay me $25. That's what the consideration is, and it also wraps up the certainty. So we need certainty to make sure that we know what the terms of the deal are. So agreement is one part of that. So usually the offer encapsulates all of the certainty and the intention part. The other thing that's really important for us to think about today is there's a really nuanced link between intention and consideration. That the judicial rationale for having consideration, even though it only needs to be legally sufficient, it doesn't need to be valuable, is that the consideration demonstrates an intention to be bound. So we think we can start off with that piece of information already about intention. So a lot of the discussion about intention, we've done the hard yards already by thinking about consideration and why we have it. So a lot of the discussion, and I'm really hoping that you've done the reading, you've looked at my little videos, that the ideas around intention, what we're looking at is when can we assume that people are intending to be contractually bound, and when might it be something else? So traditionally, there was this play or this dispute between commercial arrangements, where there is a presumption that parties intend to be be bound by their arrangements, and social or family relationships, where You know, if I agree to meet you at the pub on Saturday night, that's a social arrangement. One doesn't normally expect that one would be able to sue one's friends for not showing up. Although often there really should be consequences for people who say they're going to go somewhere and not show up. So if somebody can give me a test case to deal with that. Okay, so what I want to do is talk through in particular what those differences are. Then the other part with commercial arrangements is really trying to get our head around in what circumstances might somebody in a commercial relationship want to indicate some willingness to be bound in the future, or indicate their policy, to use the language from Woolen Mills, but not actually, and the parties not actually expect that that's a binding arrangement. Maybe it's too early to have all of the terms and conditions. We might be short of certainty. So I want to really just unpick the kinds of circumstances where intention issues come together. So that's a little bit of a sermon from me. I need to get some alleluias and some arm waving in, I think. Last week I asked you to do it anonymously. I'm not kitted up for that this week. Is there a particular piece of the preparation for this time that you have found particularly troubling or concerning, so I can put the emphasis on those syllables? I will take silence to mean it's equally confusing or equally easy. Could be either of those things. I will also take silence to mean there's a huge possibility that maybe there's no preparation done. There is the areas that I personally suspect might be the most troubling are honour clauses and preliminary agreements in particular. And my intention, unless somebody waves their hands around, is to really sort of race through a little bit. So my plan is to maybe spend an hour or so just having a look at the general principles, and then we'll do some problems. Okay, everybody here is nodding their heads, whether the rest of you are, oh, I forgot. My kid got to this slide pack last year and it was still there and has put animations in the transfers. So it kind of does my head in a little bit. He thought he was funny and it was the first time, it's just not now. So I actually think we've met the first of these objectives before we even actually start. I think you understand that there is a requirement for a binding agreement for there to be an intention for it to be binding. That part of the expectation of the parties is, or at least one party in all of these cases, is I entered into a contract with you, I entered into an agreement with you, that means you should keep your promise. So it's a fundamental premise under the common law that if an arrangement is going to be binding and it's a private law between the parties should have intended to be part of that private law, as opposed to a public law where you voted them in or you didn't, and now the law applies to you all regardless. We've got to talk about what the test is. Absolutely no surprises to anyone that the test here will be an objective one. And we're going to talk about presumptions. And presumptions are really an important concept. Those of you who are doing criminal law may well have already spoken about presumptions in class generally. But presumptions are a kind of formula or a way that lawyers get to a starting point. So they're similar to, but not entirely the same as assumptions, but they are a starting point. And then we'll talk about domestic commercial agreements and then some others. So, little flow chart. I know it's going to do my head in and you guys can laugh. So I'm coming up to the back of the room so I can read my own slide without going spare. So again, little flow chart here. Very easy flow chart, I think you can see. It's actually quite a simple process. So as a general rule, intention requires a voluntary assumption of a legally enforceable duty. And that's a large part of the judgment in Woolen Mills. So we've got two kinds of ways of flowing out of that arrangement. So firstly, if there's any, well, let's actually do it the other. This actually doesn't logically flow the way that I was about to talk about it. It logically flows, but just slightly differently. It's really easy when you have got a written agreement that has lots of clauses in it and has a clear statement. The parties intend to be bound. Okay, that makes it actually really quite easy indeed. So we've got two kinds of issues that fall out in this situation. One is where there is no express statement in the agreement that the parties intend to be bound, or maybe the agreement is an oral agreement, or maybe it's a combination of oral agreements or otherwise. So basically, as a rule, and we will talk about this case homogeneous for over and over again, I suspect, is that the category of contract goes to the onus of proof and nothing more. So all of those first cases that you had to read in relation to intention, they're important because they provide context and you can understand where it's coming from. But you will see in the early cases, we basically had a pretty much a formula. If it's a family or a social relationship, then we assume that unless it's very clearly intended to be legally binding and the parties have turned their minds to it and it's a special kind of agreement and it's a commercial in its nature, then effectively it's a there's intention and we have a contract. Otherwise, it's just an agreement between social people, family members, friends, people in a religious order, whatever it happens to be. As opposed to if we've got commercial people doing a commercial deal, then we're going to assume or presume that it is a commercial arrangement and their job is to tell us that it's not. But homogeneous changed that considerably. And actually because of homogeneous, and I think poor David Goodwin and I show our age, the little video that has Dave at the beginning of this particular setting, I don't entirely agree with what he says there. I think he makes it oversimplified because he doesn't talk about how homogeneous affects the way that we consider presumptions. So he basically says, well, we've got a social arrangement or we've got a commercial arrangement. We think about intention that way. Homogeneous has made it really clear that all that does is go to who has the onus of proof. So if we have a social arrangement, it's the party who is intending to say it's not a social arrangement, it's the onus is on them to demonstrate that the intention was that it was a legally binding agreement. But that's not a very high bar. And if it's a commercial arrangement, the onus is on the party who's seeking to say it wasn't intended to be a commercial arrangement at all. It was intended to not be binding. The onus is on them. So we'll talk about that a little bit more. There we go. The other kind of problem that you have relates to preliminary agreements. And in particular, they're addressed in the case of Masters and Cameron, and the relevant extracts are in your text and casebook. So a preliminary agreement is the kind of agreement that you enter into or arrangement that you have prior to entering into a formal agreement. So I'm a corporate lawyer, M&A, financing, technology, stuff like that. I deal with preliminary agreements all the time, particularly at the moment, do a reasonable amount of work in the fundraising space. So almost every time that a startup company gets seed capital from a venture fund, there will be a letter of intent. And the letter of intent will say, it's not binding. It's conditional on a whole lot of things happening, and the funder usually makes absolutely no promises at all that they're going to put the funding in place. It's all subject to subsequent agreements. There'll be points that need to be negotiated. The commercial reality in that space is funders very rarely walk away once they've signed a letter of intent. And sometimes formal agreements never happen, largely too because you've got to big disparity of interest, and it's very and bargaining power, and it's very rare that the fundee, the company that's receiving money, could actually sue anyway. So, sorry, I get thrown very easily with that door, don't I? I'm sorry about that. So that kind of agreement, often we don't follow up, but legally they're very rarely enforceable. Another kind of preliminary agreement that comes up often is, if I want to buy your business, one of the first things that you might want to do before we start talking about the business is you want me to enter into a confidentiality agreement. You don't want me to go and talk to your staff and tell them that the business is for sale. You don't want me to go and talk to your customers and say that the business is for sale, because that could affect your business, and we don't have an agreement yet, we're just talking about it. But very few people in a complex negotiation scenario can actually just say, yeah, I'll make you an offer today. They actually need to, we call it a say in the profession, which by the way is a very misogynistic profession, we like to lift up the skirts and have a look underneath. Or we could call that due diligence. No, it's inappropriate, but you can understand how sometimes we need to have arrangements in place, a set of rules for how we're going to go through due diligence. And so the question is, which bits of that are binding and which bits aren't? So part of our set of rules that says I'm not allowed to tell your secrets, that's probably binding. You would want that to be binding. You'd want to be able to enforce that. But the bit that says I'm interested in buying your business for a price of somewhere between $5 million and $50 million, and I'd expect to pay the purchase price in cash by the 31st of December, I don't want to be bound by that now, because I don't know what I'm going to see when I get in there and have a look. And you probably don't want to say that either, because you think your business is worth $100 million. So you don't want to constrain it in that way. So it depends. So complexities can arise there. I'm hoping that you had a look at, and it's difficult to follow if you're not comfortable with the commercial elements, but if you looked at the Spedley case, so the Bank Brussels and A&I case, so we can talk about letters of comfort. I might wait till we get to that one to get there. And then I know everybody's favourite and mine, agreements with the government and woolen mills as well. And I'm hoping for those of you who've struggled with woolen mills that looking at woolen mills through the intention lens will start to make a little bit more sense. Okay. All right, sorry, let me bring up all these slides, they might be formatted differently, but they're exactly the same as the slides that we have been using in the videos. Okay, I want to talk really briefly about Shahid. So I can't remember if Shahid is actually in your casebook or not. Oh yeah, it is, textbook. It's referred to in the textbook. I don't remember if it's extracted or not. Shahid's kind of one of my favourite cases. That is of no relevance to anybody. So Shahid is a case where there was a doctor. Her name was something Shahid, and she wished to become a member of the Australasian College of Dermatologists. So what is the Australasian College of Dermatologists?
Training college so you can become a specialist.
Yeah, it's probably a little bit further on than that. It's a club. Let's call it a club. It's to be a member or a fellow of the college. That's a statement to the world that this particular group of specialists agree that you have reached a particular standard in the practice of, in this case, dermatology. So for her to practice her craft that she had trained to do, she needed really to be a member of this club. So now I'm going to point out my bias here in relation to this decision, and there is nothing in the judgment that says this, but I think there are two things that this college didn't seem to like about Dr. Shahid. One, I suspect, is that she had 2 X chromosomes, and the other is this name here, Shahid. Anyway, their club basically said, in order to become a member, you have to go through this process and these exams and achieve this level. And she did that, and they said no. So she then looked at their rules, and there was an appeal process. That required her to pay some money, go through the appeal process. They looked at her exam, etc., and they said, yeah, you passed the exam, but we still don't want you to be a member of our club. And so she said, well, good. If she was me, she would have said a whole lot of really rude words first. And then she said, well, actually, this is a contract. I've gone through the appeal process. I have paid some money. And at the end of the day, if I do all of the things that are required by your process properly, then the end result should mean that I can be a member of your club. And they said, well, no, we're just a professional association. We have discretion. We had no intention that our rules be binding on anybody. That's just our discretion. So, again, surprise to no one, no spoiler alert. Effectively, out of this, we got a test for how we in Australia look to whether or not there is intention. So the court looked to a number of things. Firstly, was there consideration? A payment was required and it was accepted. Secondly, was their relationship one of a social nature or was it arm's length? And they had an arm's length relationship. Clearly, they didn't like her. But it was an arm's length relationship. And then thirdly, there was documentation that set out what the process was. So in order to see intention, we can use this test to look at, in relation to this particular agreement, do we have each of these elements? So the example I used earlier on, we're going to agree to meet at the pub at 7:30 on Sunday night. I'll meet you there and buy you your first beer. You can pay for the Uber home. We've got an arrangement that's relatively clear. We've got consideration, a couple of promises there if my offer is accepted. Do we have an arm's length relationship? Well, we probably do. It's, but people across the table, no. Do we have documentation or a process there? Was there something that indicates that there was an intention for that to be binding? Given the nature of the agreement, probably not. But if I were to say to you, I will only grant extensions in accordance with the actual policy of the university, and if you want to get an extension, you have to fill out exactly that form that is required and submit it through the right channels and pay $15 to the university before I will even consider it. And then I'm to say, no, I'm not even going to look at them, I don't care. But you've complied with the process, then contractually we would have all of these things. Arm's length relationship, the payment. Okay, by the way, there's no payment for extensions. The consideration there would probably be you going through the process, or actually it's a requirement of the university. I suspect it's part of your larger contract, I have no idea. But there's a documented process. So if I'm going to hold out that this is a process that you need to follow, and then I don't follow it, we have an issue. Please.
I have a question emerging out of that example.
No, you can't have an extension.
Damn. I have a second question emerging out of that example. I'm thinking about certain forms of legislation and subordinate legislation, which is regulations. In the case of a contract that I may or may not have entered into with the university, Can the university regulations be regarded, could they be regarded as subordinate to a contract?
Okay, we're going to get ourselves really off track if we go too far down there. The short answer to that, and I'm not going to be goaded further, is that we will look at those kind of things in the contents of a contract, and it will depend on the terms of the contract what can be incorporated with notice or otherwise. And so, again, it will depend on what the agreement was. So my guess is that an agreement that you have with the university is what would fall as far as the Australian consumer law is concerned within the context of standard form agreements. I'm pretty sure that you didn't individually go and negotiate separate arrangements with the university. I could be wrong, and so then there's a whole range of different things that impact that in relation to the ACL. Okay, what do I want to point out next that I think is important? Presumptions. Let's talk quickly about what presumptions are. So what do you think a presumption is? What does the word presumption mean?
It's a rule that applies unless there is evidence to the contrary.
A rule that applies unless there's evidence to the contrary. I like that definition. You're doing criminal law, is that where that's come from?
No, it's come from the intro weekend. We just got out.
All right, I will let Anne know that people have been paying for it. So it's basically a starting point. It's a baseline point. Okay, so one of the things that might not be apparent to you because of how we're exploring these contracts each time is that when there is a dispute about a contract, unless one of the parties raises a question about whether a contract exists or not, the courts will work on the basis that if people are fighting over an agreement, that there's a valid agreement. Okay, unless one of the parties has basically dealt with that particular question, it says, because think about it, if parties are having a fight, their options are to say, well, actually I didn't do that thing wrong. I did what I said I would do. But often these things come out of, but even if I didn't, there was no contract in the first place, so I didn't have to do it. So a lot of the time, the contracts that we're dealing with here, the cases that we're dealing with, are just somebody want to get out of their deal, right? Or a deal. So we start with that presumption. Most famous presumption is probably the criminal law one, innocent until proven guilty. So that's a quite hard line, that the presumption is of innocent, and then the requirement is we need proof of guilt. So not proof of innocence, not on the balance of probabilities, but actual proof of guilt. So that's a hard line presumption. Presumption in relation to intention are relatively soft line presumptions. So we've talked about these starting point presumptions before. So they start with commercial agreements. We assume that the parties intended to be bound. And in non-commercial transactions, we assume that they do not have intention to create a legal relationship. So we need somebody to argue to the contrary. Now, both of these are rebuttable presumptions. What does that mean, rebuttable? Yeah, you can refute them. We have this starting point. If neither of the parties have an issue with it, so let's say it's particularly with commercial agreements, if the presumption is that that we've got intention, unless one party comes to rebut that intention or rebut that presumption, try and eliminate it, then basically the court won't even inquire into intention. And so that leads us to this question of the onus of proof. So who is the onus on to rebut the presumption? So in a commercial agreement, if you're seeking to demonstrate that the agreement should be enforced, and the other side is saying, well, no, there was no intention for that to be a binding agreement, it's the other side who needs to rebut the presumption. And then you need to rebut their rebuttal, I guess. So, homogeneous. again, homogeneous. By the way, I'm never 100% confident that I'm saying homogeneous the right way. I had a Macedonian student a few years ago who says that that's okay, but I don't know whether it's a hard G or not, and if anybody can tell me at some point, we'll go. So I just like to think of him as the bishop. So the bishop, served the Greek Orthodox community of South Australia for a long time. He did baptisms and weddings, he ate too much baklava at funerals, he dealt with disputes between parishioners, and he spent 23 years doing this, basically without any holidays and without any break. And then he resigned, and he made a claim for his long service leave and his back holiday pay and all the rest of it, and the community were outraged. But Bishop, they said, you had the privilege of serving our community for all of that time. You were our spiritual leader. You were not our employee. It was your privilege to never get a weekend off. It was your privilege to have that really scary loud noise that happens at an Orthodox baptism every now and then that scares the bejesus out of the rest of us. There was never any intention that you would be bound. And up until Ermogenes, that was a pretty standard argument. We can go through at some length, if you really want to, some of those old cases, but you need to read them to understand that. The High Court, this ended up in the High Court. And the High Court, it's a really interesting judgment because they talk in it, and for those of you doing jurisprudence might find it particularly useful, because they talk about how the law is a living thing and that we can't let a presumption, particularly a presumption that comes out of a historical place, risk ossifying the law so that it's not relevant to people and the communities that it serves. So it's a very forceful judgment, and it says essentially, at best, the presumptions really only go to who has the proof of disproving them, who has the onus of disproving them, I should say. It is not a formula, this is a social relationship, therefore no agreement. If it is even close to a formula, it's this is a social relationship, therefore if you want to demonstrate that it was intended to be binding, the onus is on you because you want to make that demonstration. Or this is a commercial relationship, it looks like a commercial relationship, therefore if you want to demonstrate that there was no intention, the onus is on you to demonstrate that there is no intention. Quote from the case which I particularly like. Not only is there obvious difficulty in formulating rules intended to prescribe the kind of cases in which an intention to create contractual relationship should or should not be found to exist, it would be wrong to do so. So, how do we find intention in this context? No surprises to anybody that we need to look at it objectively. The test that came out of Ermogenes asks us to look at, well, what is the subject matter of the arrangement? This is not a going to the pub arrangement. This is 23 years of a very precise set of services that a certain individual provided to a community that had a hierarchy and a structure around it. What was the status of the parties? He was their so-called spiritual leader, but in relation to the way that the parishes underneath him were managed, in relation to finances, etc., he had effectively a board that he had to report to and take direction from. What kind of relationship did they have? By this stage, not a good one. High Court, that's going to cost your average church a little bit of money, but let's face it, most churches are not shy about litigating these days. What was the relationship of the parties? This is a command and control relationship. There was a board that was the boss, and he was required to do things. He had input, they took his advice, but ultimately the board made decisions. The board made decisions about who he could fire and hire underneath him and how the relationship worked. And we love it when we see this in a test because it's so unhelpful until it helps us, other objectives surrounding circumstances that might be relevant. So the High Court is clearly in this case putting together a test for how we look for whether intention exists or not. So I've talked about this. So since Irma Genus, we're not starting with the formula anymore. So, and yeah, I've just said that over and over and over again. So, in order to determine intention, we need to do these things. We need to think about what the parties intended from the nature of and the circumstances of their agreement. If that's not clear, then the courts, and often the agreement can be clear, can say, the intention of the parties is this, will be binding on each of them. The parties intend that clauses 5 to 10, which deal with confidentiality and an exclusivity arrangement, are binding, and any provision that's relevant to understanding those clauses will also be binding. But the other clauses, specifically the ones that deal with anticipated price or how long our negotiations will take, they're not intended to be binding at this stage. Those kind of things. So you can put it into the agreement itself. But where the agreement is silent, then the judge can have a look at all of the circumstances and come to a view. And the onus of providing legal intention rests with the party alleging that a contract exists in a commercial context. Sorry, in a social or family context. Got that completely back to front. And it's the other way around if it's commercial context, that the onus will be on the party seeking to establish that there is no intention to demonstrate that there is no contract. Okay, so these are the ones I want to talk about, some tricky situations, some commercial contracts. Oh, sorry, I just barreled on. Questions, concerns, frustrations? Shall I send my son compliments for the ridiculous way that where these slides are merging? Okay, I want to talk particularly about letters of comfort. So, these are covered under the certainty area in your textbook, but I want to mention them here because, in my view, this is where it makes more sense to understand them. So, a court won't enforce an agreement to reach an agreement. So, let's just think about that. We can't agree to agree. Let me give you a context. I want to sell you my business. You want to buy my business. We've listed out all of the things that will involve. I'm going to transfer all of the assets to you. I'm going to ask my employees to sign new employment contracts with you and make them redundant myself. And then there's a clause that says, I'll come and work for you in this business for a period of a year and we'll agree later how much you'll pay me and what my hours will be. Okay, so the clause is an agreement for us to agree. I suspect with what you know about contract law already, that kind of fails our test of what agreement is. And you can see how it fits in the certainty area then. That at best we can agree that I won't go and work for anybody else for at least 6 months. And if you ask me to, I will come to you and have a conversation with you in good faith. So my agreement is I'll show up to the meeting and I'll drink your tea and coffee. And if it says good faith, then there would be many judges. That would mean that I would have to actually have a serious conversation with you. But I can't be required to agree, and you can't be required to agree at either. We can agree that we will negotiate, but we can't agree that we will agree in the future. So look out for that, and you see it all the time. Commercial people do this all the time. And commercial people do it successfully. 85% of the time. That's just a random figure, by the way. They have no statistical basis for it. It's possibly even higher than that, that people say, oh, we'll get together next Thursday and we'll agree, okay? Yes, and they get together and they do agree. But they can't, if you fail to actually reach agreement next Thursday, there's no basis on which you can sue the other party. You agreed, you'd agree with me. It's like dealing with a 2-year-old, really. So, honour clauses. So an honour clause is a clause or an agreement where a party says, like Woolen Mills perhaps, there are other government cases in particular, what we're going to do, we agree in the future we'll do something. We have a policy of doing something in a particular way. It's our intention to do this, but we're not really making a promise. We're representing to you, like, we've always done it this way in the past. I can't see any reason why we would do it differently, but I'm not going to promise you. So Rose and Frank and Co. and J.R. Crompton Brothers, it's a very old English case, well, not very old in contract law stage, but it's 1923, so it's going to have its 100th birthday before too long, in 5 years' time. Rose and Frank were sales agents for a really long time, and they executed a contract, an arrangement, to continue their present arrangements. And the clause itself, or in the document, said, this is not a formal or a legal arrangement. It's just a record of our intention to which Rose and Frank, I think it is, Crompton Brothers, honourably pledges themselves with mutual loyalty and friendly cooperation. In other words, we've always done it this way in the past. We can't see any reason why we're going to change, but we're not saying we're going to be bound by this. Crompton terminated the agency and Rose and Frank claimed damages. They said, well, we set ourselves up on the basis that we're going to continue being your sales agent. You signed this agreement. What happened? The document was unenforceable because there was a clear statement of, in this case, lack of intention. So whilst we have a presumption in a commercial relationship, which this is, the party seeking to demonstrate that they had no intention were able to point to this clause which says, we don't have this intention. So yeah, we might suck as humans because we said we'd do this honourably and now it turns out we're dishonourable, but that's different from being legally bound. It is important, though, to recognise that once you've actually got an agreement, you can't exclude the jurisdiction of the court. So you can't say, yeah, this is a binding arrangement between us, we're going to keep our promises, but if there's a dispute between us, then we're not going to go to court, we're going to sort it out ourselves. It's one or the other. You either have an enforceable agreement, which means that ultimately any dispute can go before a court, or your intention is that it not be binding, and as a consequence, it's not a matter for the courts. So, letters of comfort, which is where I'm going, which is a particular type of honour clause. So what a letter of comfort is usually works like this. You will have a subsidiary company that needs to borrow money. So we have a parent company which may own 100% or something, or a majority of the subsidiary company. Now I doubt there's anybody in the room who's done corporate law yet or company law yet, but I don't think it's too hard to think about in the sense of companies are created so that gentlemen can take risks with other gentlemen's money. This idea that of a company is, and many of you will have seen company name here, Pty Ltd, Proprietary Limited. That means that the ownership is limited to people who the directors agree can be the owners, and it also means that liability is limited to the amount of money that is paid up on the shares, or can be paid up on the shares. A public company, they can't limit who the shareholders are, but it's still limited in a sense of liability. So if you form a company, it has 100 shares with $100 a share, you basically put $100 into its bank account and you own the 100 shares. From that point on, the company trades, and at some point in time it might have $2 million in the bank, and at another point in time it might owe the bank $2 million. If at some point it goes bust, whatever assets it has will be divided up amongst its creditors. But the creditors, again, I'm oversimplifying, you'll learn all the reasons why this doesn't always happen, but mostly this is how it happens. Creditors can't come knocking on the door of the people who own the company unless they haven't actually paid for their shares. So say you actually just hadn't paid up, they can come to you for the $100 that you owe for those shares at the beginning. But that's it. That's your liability as a shareholder, is limited to your investment in the company. So big companies will often decide that they're going to do some risky stuff. So the risky stuff that we'll see in the next couple of cases involves basically hedging on a stock exchange, or hedging on a foreign investment exchange, or hedging in a tin market, volatile markets. So essentially they will create a subsidiary. So there are shareholders who own a company. Sorry for you at home, I'm doing this with my hands. Shareholders own a company. The company in turn hives out some of its liability, so for a risky venture, into a subsidiary. So say that subsidiary wants to borrow some money, or even the main company wants to borrow some money. The bank might look at what they're doing and say, that looks risky to me. Even though I'm a bank and my job is to lend you money so that you can go and invest it and, return profits to me, I don't want to lend you money if there's any risk at all of you falling over. So what I want is your parent company to give some kind of guarantee. Now, many of you have been involved in small businesses or family businesses, may have found that you want to go, for example, and rent some premises. The company goes to rent the premises and the landlord says, well, that's all right, but I want the directors to give personal guarantees just in case the rent isn't paid. It's exactly the same thing. So often what happens at that point is the parent company says, well, no, I'm not interested in doing that. I'm actually hiving off this risky business into a separate entity for the purpose of taking risk and limiting my liability. So some of them will say, either lend me the money or don't. Some of them will say, lend me the money and charge me more interest. I'm prepared commercially to do that. Some of them will get 4 or 5 different banks and go with the best deal, which they don't need to do. Some of them will provide some sort of security for the loan. There's so many different commercial outcomes. But one of the ways that we see it happen, particularly when we're talking about millions of dollars, is that the parent company will give something less than a guarantee, a letter of comfort, that basically sets out what it will do if the subsidiary ends up in trouble. So to provide additional comfort to the bank on top of the usurious rates of interest that no doubt they charge. And so the question often is when things do go pear-shaped, is that letter of comfort a binding promise or not? So just thinking about it to start off with, what do we need to think about in order to work out whether a letter of comfort is a binding promise? Intention. Anything else? Just before we unpick intention, because that's clearly where we are today. We need to look and see if there's an agreement. Ideally an offer and acceptance, but if not, a meeting of the minds. We need to know that there is consideration. Sometimes that consideration is the promise to enter into the relationship with the subsidiary. Often, one of the reasons why we use this term guarantee is a guarantee is an equitable instrument. So often you use a guarantee because you don't need to have consideration in a deed of guarantee, right? So I'm promising I will do these things if it all goes pear-shaped because you're helping my mate out or my subsidiary or my child or whatever it is. So consideration is often an issue in these cases as well. Don't immediately jump to its just intention. I want to talk about intention today. We also need certainty. Like, exactly what does comfort mean in this situation? Like, are you just going to say, oh, too bad, so sad, I'm really sorry, take the guys out for a drink? Or are you actually going to step into the breach and pay all or some of the outstanding money? Are you going to step in and pay the fines or the penalties? What are you going to do? So let's have a look at the cases. So there's a very limited number of you who are old enough to remember Spedley. Christopher Skase mean anything to you? Some of you? Yes, good. So this is a case that involved Spedley Holdings and Spedley Securities, which were speculative investors in the 80s. At the helm was a guy called Christopher Skase who left the country, got very ill and effectively was never able to be extradited back here for failing to pay tax, for failing to, or manipulating the stock market. The list of things that he was accused of but never stood trial for is significantly long. So this company, ANI, Australian National Industries, used to be a massive company in the 70s and 80s in Australia. And ANI held 45% of Spedley Holdings. So it was a significant investor in that company, which was a listed company on a stock exchange. In turn, Spedley held 100% of Spedley Securities, so a subsidiary that was formed for trading securities. Spedley Securities secured a $5 million loan. It feels very much like Austin Powers now. The numbers seem quite small. $5 million. $5 million to trade on the stock exchange. When they sought that money, they sought a letter of comfort from ANI. So not even the majority holder. They're like, yeah, we'll lend them some money to do this, but we're not 100% sure about this. So we would like to get a letter of comfort from ANI. I think my next slide has the terms of that letter on it. Part of it, yes, that's good, because otherwise it has the answer for what I'm going to ask you. So there were two relevant terms. If you look at the decision, it's quite a long decision. I think you get to read most of the agreement in there, but this is a short version. ANI said in that letter, it is our practice to ensure that our affiliate, Spedley Securities, will at all times be in a position to meet its financial obligations as they fall due. It is our practice. Then they said, effectively, if we cease to have a large interest in Spedley Securities, we'll tell you 90 days beforehand. So the market tanked in 1988, tanked big time. Everything was chaotic and ANI sold its shares. Spedley defaulted on the loan and Bank Brussels went to ANI and said, yeah, we want you to fill in the breach. We want you to step into the shoes. So the issue in the case was, what was the legal effect of the arrangement, this letter of comfort? Was it intended to be binding? And if so, was it a contract? Or was it just a letter of comfort? Just some statement. So, regardless of whether you've read it or not, what do you think, based on what you can see there? Actually, before you answer that, Anybody got any ideas as to why Bank Brussels would have wanted this 90-day notice provision in their letter of comfort? Or why I think that's a relevant provision?
If they were supposedly relying on A&I to support Bedley if they got into trouble, then if they'd got rid of their interests, they'd want to know about it.
Yeah, so if they were relying on A&I, and A&I's promise is effectively, we ensure that the affiliate can pay its bills, then they want to know in advance if it's going to cease to be an affiliate, because that's relevant. 90 days is a really long time on a stock market too, and sort of contrary to this too, for just if you're interested, the listing rules, even back then, would have said you can't tell one person that you're going to dispose of a whole lot. That's a significant interest in a company. That actually has takeover ramifications if you're going to sell 45% of the company. You can't just go out and tell one person without telling the whole of the market. And of course, if they went and told the whole of the market, that actually impacts the price that they can get. So there are a whole lot of other bits and pieces going on here. So back to my original question, what do we think about this letter of comfort? Based on what you know, what do we think about intention? Did they intend to be bound objectively?
I think the language is a bit Manchester City Council.
I will pay that. I think
Yeah, it
that
is our
Manchester City
practice to
Council,
ensure-
it is our practice to ensure.
Not we agree to ensure or like we will.
Okay, so objectively that part appears to
immediately-
demonstrate a lack of intention to be
Although
bound.
The second part, on the other hand, to me feels more like it would be. It seems like a. What?
Yeah, a direct promise.
Yeah, to that.
So,
Whereas for them's a bit more of a
we comfortable with that?
It's Rose and Frank as well, right?
Yep. So, questions that the court had were, was there an intention to enter into a legal relationship, and are the terms of the letter sufficiently promissory in nature? So the court looks at the actual terms objectively. And you're absolutely right that at the end of the day, the court looked to that promise in relation to the 90 days. So they said that the starting point is a prima facie presumption that in a commercial transaction, the intention is to be bound. So you need to be, in a commercial transaction such as this, really clear that your intention is not to be bound, to rebut that. And the onus of proving the absence of intention rests with, in this case, A&I. The fact, that is just doing my head in. In the break, I'll try and stop that, but then we're not going to look at this after the break. So because the letter that A&I gave included enforceable promises to provide notice, then it was reasonable on an objective basis to see intention, because there was basically a get out of jail provision for them, that because that the bank could rely on this idea that they would give notice if they cease to be providing affiliate support. And because we're starting with this presumption that they are intended to be bound, and that it's also relevant in the case that A&I provided that support relatively willingly, that it offered that support in order to raise the funds. The reality is, at the time, A&I were big and ugly enough, it could have loaned $5 million directly if it wanted to. Instead, it provided that facility support. But then we get to Kleinwort-Benson. So this Kleinwort-Benson and MMC. So MMC, many of you will have heard of anyway. It's a very large miner. It's actually Chinese owned now, and it's it basically, in relation to this, it was doing tin mining. I'll show you a I think my next slide has got the corporate map for it. In this case, MMC gave a letter to its bank, Kleinwort Benson, in relation to a subsidiary that says it's our policy, favourite word here, it's our policy to ensure that, the subsidiary in this case, is at all times in a position to meet its liabilities to you. So let me just show you what that looked like. So basically here, MMC owned 100% of a company called MMC Metals. MMC Metals was going to trade on the tin exchange in London. Very speculative market. Kleinwort Benson was advancing 10 million quid. So roughly $25 million, right? So bigger stakes. And this is pretty much at the same time period. So differences that we can see, MMC is 100% owned here. ANI had 45% of the parent, who in turn had 100% owned, so it's a much more direct ownership. There were 2 letters of comfort given on very, very similar terms, and there was a master agreement, financing agreement, where MMC received group financing from Kleinwort Benson as well. It's also, I think, relevant that during the negotiations, Kleinwort Benson sought a guarantee and MMC said no, and they negotiated a higher rate of interest. They said no, and we don't want a guarantee. This is a speculative investment. If you're not happy with it, we'll go to another bank, or you charge us greater interest, we'll find another way of dealing with it.
As in MMC being the guarantee?
Yeah, so the question, Kleinwort Benson sought a guarantee from MMC, so that if MMC Metals defaulted, MMC itself would have to fill in the breach. So, just returning to that clause, it's our policy to ensure that the subsidiary is at all times in a position to meet its liabilities to you. No 90-day promise. What do you think, given what we saw in the other case? Same result as the other case, different result as another case. Oh, and the words contrasting result probably give that away. Yeah, it does look a bit like a template clause, I agree. And look, your next assignment, you'll get to look at some template agreements and have a think about how template agreements might work and when you need to vary them a little bit. So let's just move on. Let's see what. So in that case, oh no, that's just facts. Forget that I write the facts down. Don't worry, you've got the slide pack, you can find them. First instance, commercial people intend their agreements to be binding, and the letter contained a contractual undertaking that was effectively to underwrite the subsidiary's indebtedness. So at first instance, but ultimately on appeal, Lord Justice Gibson, the letter contained no contractual undertaking, was merely a representation of fact that only carried with it a moral obligation on the part of MMC to meet MMC Metals' debt. So what's the difference between those 2 cases? The 90-day clause is absolutely relevant there. The language is different. It's also relevant that there was clarity in the negotiation, that the history showed what intention was. So in the negotiation, they were asked to give a guarantee. They were very clear, we don't want to give you a guarantee, we're prepared to pay more money, ultimately, or for the subsidiary to pay more money, but we have no intention of providing a guarantee. Now, when we talk about the parole evidence rule and the extent to which we can look at evidence outside the written document, when a document of itself looks like it contains the entire agreement, that might just resonate in your mind a little bit, that the court is looking outside of that. And there are exceptions to that rule that allow for the understanding of the context for the sensible reading and working out whether or not the letter is the only the letter or the agreement is the entire agreement or not. But if that's not clear when we get there, remind me that I raised it with this case.
Under Bank Brussels, if that was to occur today, would the Corporations Act 2001, the insider trading provisions, would that prohibit that contract being enforceable by virtue of it being illegal?
If the parties were listed, it wouldn't be entirely impossible to have the clauses, but again, we'd be going into company law there. When the agreement was made, if the company was listed at that point, the disclosures would need to be made. Look, at the end of the day, they were cowboys back then. They were really... And A&I collapsed at the end of the day. It had dodgy deals left, right and centre. But yeah, there would be some listing rules issues. There would be some insider trading issues. The activity, I don't think it would be void for illegality. It's just that in order to perform the obligation, disclosures would need to be made at the stock exchange level, and it would be commercially problematic for them if they actually did what they'd promised to do. If in fact they had promised it, that becomes the question, doesn't it? If they had in fact promised it, then as a consequence of that, yeah, it would be, you would have directors' duties issues, you'd have all sorts of issues. Okay. Family and social relationships. Actually, no, I'm going to go straight through. I want to talk about all of the commercial arrangements first. I want to talk quickly about Masters and Cameron. We can go back to the family and social stuff if you need to, but I think when we do our little game in a minute, we'll have plenty of opportunity to talk about those things. So I started talking about this in my little intro, that a preliminary agreement is often the preliminary to reaching an agreement. So documents or processes that outline how the parties are going to negotiate or what's going to happen next. And the question often becomes, is this set of rules actually binding on the parties, or is it just the way that the parties have said in honour that they're going to negotiate with each other? Often you will see draft documents or term sheets that say they are subject to contract. This idea that unless and until both parties sign a written document, that there is no agreement. But as we know, the elements of formation of a contract are agreement, consideration, intention, certainty. None of those things are signatures on a piece of paper. So it becomes an objective test whether or not the parties have actually reached agreement or not. And a piece of paper that's been signed by both parties is really helpful in meeting that objective test. But when you've got a piece of paper that's been signed by both parties but says it's subject to something happening later, then it can get a little bit tricky. So, Masters and Cameron, High Court decision from 1954, one of the most often cited cases. There's actually a great little book that came out about a year ago. Oh, I can't remember exactly what it's called. There's a copy in the library. It's got a green and beige cover, and it is the 100 most cited decisions in Australian law. It's got 4 or 5 different indexes, by the way, which is quite helpful. Like there's just the alphabetical index. Then there's a subject matter index. So like contract law cases, you can see which ones they are, or tort, or whatever it happens to be. And basically each of them, a couple of guys have put it together. They were paralegals at 2 of the very big firms. And it's kind of like, you know, it's I think actually sort of like paralegal contraband. You know, people have made these summaries of the cases and then they've shared them amongst each other over the years. And so they've been collated, they've used Jade to work out what's most cited, and anyway, and now then Jade gave me a copy actually. So...
Is that called leading cases in Australia?
Yeah, leading cases in Australia. I knew it had a really unimaginative title and a really unimaginative. That's what makes me think it's contraband. You know, like people have tried to make it as unassuming as possible, but really, really useful little book to have a look at. And they have a summary of each of the. So they're listed in order of how often they get cited. Then listed by, they've got a summary of what the case and the key points are, decisions that follow that are particularly useful. So Masters and Cameron, good little summary of that in there. And it can be kind of a useful way to pick out the key points. So, just for those of you who really love being law students and are wondering what you're going to read over summer, there you go, one step ahead. So basically, there are 3 categories of preliminary cases that Masters and Cameron came through. I'm not going to bother you with the facts because they're not particularly interesting. We end up with this formula. So we've got agreements where the parties have finalised the terms and they intend to be bound straight away. Where these are agreements that are binding whether or not something else happens. Okay, the intention is to be bound immediately. There is no requirement for that formal document. If a formal document happens, great. If it doesn't matter, we've still got an agreement. We've got where the parties have reached an agreement on terms, but the performance of that agreement is conditional on signing a formal agreement. The parties are bound to sign the formal agreement. So they have an agreement to sign. It's not an agreement to agree because all of the terms have been agreed already. What they are bound to do is sign the agreement that reflects those terms. If there is no intention until and unless the parties execute a formal contract, then it's not binding. So basically, Masters and Cameron says, look at your preliminary relationship. Which of these categories does it fall into? And then you know whether it's binding or not binding. Oh, sorry, I won't bother about that. So, basically, the agreement in Master and Cameron said, this agreement is made subject to the preparation of a formal contract of sale, which shall be acceptable to my solicitors. So which of those 3 contracts, or 3 categories, I should say, does that fall into?
No intention until formal contract?
Subject to the preparation of a formal contract of sale.
Which shall be acceptable though?
Which shall be acceptable.
What isn't acceptable?
The third one.
Oh, sorry, I'm not sure why I'm doing that. Oh, sorry, So in Masters and Cameron, because it just needed to be acceptable to a third party, the court found that the parties themselves had reached agreement on the terms. The only condition, just going back one, oh, I hate it. I've got to fix up my pointer. So in that case, there was agreement on the terms, but performance is conditional on execution of a formal agreement only. So it fitted into the second category. There is this talk about a 4th category, which comes from a case, Borkham Hills Private Hospital and GR Securities, where the idea is that where there's a category where the parties intend to be bound immediately and exclusively whilst expecting to make a further contract later on. Now this, in real terms, is something that I see all the time. The intention is that I'm not going to talk to anybody else about selling my business or selling my company other than you, with a view to us ending up with an arrangement to sell, but that exclusivity arrangement is binding and subsequently it isn't. There's a good argument, and your textbook deals with it quite well, that this is really just another way of expressing the 3rd category. It doesn't really matter, it's just a way for you to start thinking those things through. Okay, quote here from relatively recent case, Pavlovic and the Universal Music in Australia. It's well established the question of whether the parties intended to bind themselves to a contract is to be determined objectively. Having regard to the intention disclosed by the language that the parties have employed. In cases such as this one, which don't depend on the construction of a single document, and the emphasis here is mine, what is involved is the objective determination of the question from the communications between the parties in their context and the parties' dealings over time leading up to the making of the alleged contract. Again, we're just going back to what we already understand about how we work out whether a contract exists. So we look objectively, not at what did they intend, but what would a reasonable person have assumed that they intended based on what they wrote down and how they behaved themselves in a particular context.